PowerPoint up. Susan, if you want to go ahead with your introduction.
Okay, terrific. Thanks so much for having us up to your seminar today. It's always a pleasure for me to come and speak to the counties and all the various county officials. I so enjoy working with all of you, and I've had the pleasure of working with many of you in this room on some recent litigation. And I do want to tell you one thing. Having worked with Corby and Johnny on litigation, you have terrific support from these gentlemen. They do such a terrific job. They do a terrific job with the attorneys that work for you and on your behalf. And they fully support our efforts to make sure that everyone in the state of Utah understands that you are not easy targets. And we fight hard and we fight long, and sometimes it takes 2 appeals to the 10th Circuit, as Corby and Johnny and Weber County knows for me right now. So we're gonna win that one and finally have it put away, but they know darn well in the county of Weber that we do not roll over and play dead when it comes to litigation against the counties, and I think it's because of their strong leadership. Now, when we start talking about nepotism, I thought it was a funny topic for me to address. Having been in a law firm when I first started practicing law with my father and my brother, and so nepotism was a little bit of an issue there. And then later on in my life, I practiced law with my husband and tried a number of cases with him. He also tried a few cases for the counties through the years. And also now I practice law with my brothers again. And so I think I know nepotism firsthand. But let me tell you this, there are many benefits to working with family members, as I'm sure many of you know. There are also some disadvantages, and Louis, my brother, who is here with me and going to help me present today, can probably tell you more about the disadvantages of having to work with his older sister. But with that being said, let's talk about nepotism. And also I wanted to let you know, I prefer it if at any point in time during the course of these presentations to you today by me and Louis, interrupt with questions, interrupt with any kind of a situation that you're presently handling, and we'll try to address those issues as we go. I know this is the last presentation of the day, so we're going to try to go through this in a fairly fast clip, but stop at any moment in time. Now, when we talk about nepotism, there's various policies that different governmental entities as well as businesses have. Now, there is a unique nepotism policy in the country of North Korea. As you know, the dictator there just kills his family members anytime he's working with them. So we don't advocate that kind of an approach.
I don't think that's covered by use.
That use of you covered, you know, that's one way to get rid of them. We're going to cover some of the issues that come up in the state of Utah pursuant to Utah state law. We're going to go through the statute in some detail, just because I think it's a good refresher for many of you. And for those of you who are new in your positions, hopefully some of this information will be helpful to you. When we talk about nepotism, what we're really saying is favoritism towards family members or close friends and allies. This dovetails nicely with our conflicts of interest policies, and it also has implications when it comes to EEO policies. As you might imagine, if a business or a governmental entity only hires individuals or has a preference for individuals that are related to other members, I represent some companies where there is a lot of hiring of family members. Some of our big utilities that I work with, there's clearly a preference for family members. We'll see generation after generation. The problem with that from an EEO standpoint, of course, is this, that family members tend to be from the same race, have the same religion, have the same background, and so on and so forth. So that creates some EEO policies. Also, as is obvious, there's a lot of conflict of interest kinds of issues that may arise as a result of only hiring family members or showing a preference for close friends and family members. Here's another definition of nepotism, and I think most of you in this room know what that means, generally speaking. Louis found some really cute cartoons that I think break this up a little bit, but it does talk a lot about only hiring sons, brothers, sisters, mothers, and so on. Here's some examples of nepotism in our own government through the years. And it's part of the reason why we have the laws that we do and what sets us apart from certain other countries. John Adams was one that had a number of family members, in particular his sons that held high government office. And he actually thought there should be some sort of hereditary preference for individuals from different families. It's hard to believe because he actually was one that crafted the Declaration of Independence with Thomas Jefferson and had a lot of input into that. Zachary Taylor also showed a preference for family members, and you can read some of these things that they did. Ulysses S. Grant was really the champion of nepotism. He hired over 40 families. There was so much corruption in his government as a result of family members feathering their nests, lining their pockets, and so on and so forth. Rutherford B. Hayes, another example. Woodrow Wilson, as some of you may know, his son-in-law was a key government official and actually did a lot to run the government, especially after Woodrow Wilson had his stroke. There's also a lot of reports in history that when Woodrow Wilson had a stroke, his wife actually was the real president of the United States, and it was kept hidden from the people as to how debilitating the stroke was for many, many years, as most of you know. I don't see that ever happening in this day and age with all the communication that there is out there. Franklin Delano Roosevelt hired several of his sons, and his daughter was more or less the first lady for the last 2 years of his presidency. John F. Kennedy, of course, hired his brother as the Attorney General. As a result of this, there was federal legislation passed that prohibited nepotism in federal government jobs. Bill Clinton also, there was quite a bit of cronyism or friendships and things like that, where he brought in a lot of individuals like that. In particular, when he appointed Hillary to head up the committee that was dealing with health insurance issues in the United States, there was a lawsuit that came about as a result of that. And it's actually that particular lawsuit and that finding of the court that said that in that inner circle within the White House, the nepotism rules are different and don't necessarily apply, which made it possible for President Trump to have so many family members so close in his inner circle. George Bush hired a number of friends or friends' children and put them into key positions. Now, for some inexplicable reason, Lewis did not choose to put President Trump up there amongst the individuals that had perhaps nepotism issues. The other day as I was getting ready for the presentation, I said, well, why not? He says, oh, it may be too soon, maybe too soon for people to really look at that issue. I read the 17-page legal opinion that he got from legal counsel to justify having his daughter in the positions she's in and his son-in-law in the position he's in. And a lot of it goes back to that era decision by the courts. Now we're going to take a few minutes to talk about the Utah nepotism law. And I assume that many of you are very familiar with this, and hopefully you can help guide all of us through this if you have some specific things that you would like to talk about. When we talk about the Utah nepotism law, I'm trying to decide if I can get to see this. I just wanted to bring out a couple of the aspects of it. What we basically say in the state of Utah is that if you are in a public position, you cannot hire family members to work for you unless there are certain criteria that are met. And we can talk about that. There are definitely exceptions. And the exceptions really, I think, are geared towards situations where you may be in a sparsely populated county, and there may not be as many individuals in that county that can fill these particular roles and positions. But basically what the Utah nepotism statute says is that you cannot hire somebody who is a relative. It defines relative as father, mother, husband, wife, son, daughter, sister, brother, grandfather, grandmother, uncle, aunt, nephew, niece, grandson, granddaughter, decided to look on this list. I think it's totally agree. And when we talk about a public official, oh, is this? Oh, okay.
Sorry, into the microphone.
Oh, okay. This is the problem when you're a little bit shorter than most people. Okay, I've got it. Okay, I've got it. When we talk about public official, the statute specifically says that that means a person who holds a position that is compensated by public funds. So virtually everybody in government. The Utah Anti-Nepotism statute also talks about no public officer may employ, appoint, or vote for or recommend the appointment of a relative in or to any position or employment when the salary, wages, pay, or compensation of the appointee will be paid from public funds and the appointee will be directly supervised by a relative. Now that, I think, is a key thing. We're going to talk about some best practices as we go through this today and maybe end with some of those. But I think the key here is directly supervised by a relative. So in your situations where you may have family members that are employed by the county, it's important to do whatever you can to make sure that the relative is not supervised directly by another relative. There are some exceptions, however, to this statute. Number one, the appointee is eligible or qualified to be employed. So in other words, we have to make sure that if we are hiring a relative, that they are eligible and qualified for that particular position based on state law. Also, that the appointee will be compensated from funds designated for vocational training. That would be another situation where that's an exception to the nepotism law in the state of Utah. Another exception is if the appointee will be employed by 12 weeks or less. So if you have somebody who's coming in for the summer to work in the Parks Department or something like that, and they're going to be employed for 12 weeks or less, then you don't have to strictly comply with the nepotism law. Or if it's a volunteer. This is another way that the Trump children were excluded from nepotism application because of the fact that they're employees, but volunteer employees, so that's important. And then another exception, the chief administrative officer determines that the appointee is the only or best person available, qualified, or eligible for the position. Now when we talk about this, and you'll see this throughout the presentation too, another best practice, of course, is to post the positions. If you post the positions and you only get one applicant, and that applicant happens to be a relative, and that applicant otherwise is qualified and available and eligible for the position, then you don't have to strictly comply with the anti-nepotism statute, and you can retain that person. No public officer may directly supervise an appointee who is a relative when the salary, wages, pay, or compensation of the relative will be paid from public funds. Now what this is focusing on the appointee. The first list that I read to you dealt with the public official. This list, same statute, next phrase in the statute really deals with the appointee. And it's the same kind of exceptions that apply in that situation. So we're talking about the appointee being eligible and qualified, the appointee, if it's for vocational training, then it doesn't have to comply, 12 weeks or less, doesn't have to comply strictly. Volunteer, then it doesn't have to comply, and so on. So it's the same kind of criteria there that applies to the appointee as well as the public official. And then again, the key thing here is the direct supervision. I'll say that time and time again. I think when we're talking about direct supervision of a relative, do whatever you can to avoid that from happening. And that's good for a lot of other reasons too. I do a lot of training in sexual harassment and discrimination to different groups, including the counties and including different businesses that I deal with and I represent. And of course, when you have a situation where you have a relative that's supervising another relative, you get into the concerns of favoritism and what have you, and next thing you know, you may not only have a claim under the nepotism law, you might also have a claim for some type of discrimination in the workplace. And so it's always a good idea to make sure that the public official is not supervising someone they're related to. Now, when we look at the nepotism laws too, there are some other exceptions that may apply to your situation in your county. This is the group of exceptions that really deal with smaller or sparsely populated counties or jurisdictions. In this situation we're talking about, the statute does not apply to the employment of a relative if fewer than 3,000 people live within 40 miles of the primary place of employment. The job opening has had reasonable public notice, and again, I emphasize that I think it's important to always post positions in government, in businesses. In one of my former lives, I worked for a Fortune 500 company, and we actually got sued for discrimination, and one of the remedies to the discrimination in the workplace was that we posted extensively virtually all positions in the business, and we had 130,000 employees in 27 states, so it was quite an undertaking to do that, but that's what we had to do in order to comply with a consent decree ordered by the federal court, so that was important. Make sure that if you do in fact hire the relative, that the relative is the best qualified candidate for the position. That's critical. If on objective standards, on objective review, if this person is the best qualified, then you can justify it. You can make sure that it complies with the law that way. Now, in this respect, each day a relative is retained in office by any public official shall be regarded as a separate offense if it's in violation of the nepotism statute. Any person violating the statute is guilty of a misdemeanor, so that's important to know as well. Now, Louis is going to talk for a few minutes about some of the cases that have come down, and I can tell you that there have been very few cases in the state of Utah that deal with nepotism. I think generally speaking, our employers do a very good job in this respect. And so I think that that's fortunate for us. But these few cases that he's going to talk about really point out some examples of where nepotism can become a problem in the workplace. So take it away, Louis.
And just to clear the record about, Susan was talking about nepotism in terms of our family employment, I want to reemphasize the best qualified individual. That gets me out of that. All right. So again, I did find a lot of cartoons, so I like to put those in. As Susan was saying, we have done a lot of research on cases dealing with nepotism in the state of Utah, and we found a grand total of 3 cases. So it's not like we're picking the best 3 cases to put in this presentation. We found the 3 cases. The most important for all of this, for this anti-nepotism statute, if you'll note, the date goes back to 1953. Backman versus Bateman. And in this case, as a result of this case, there was an exception that was added to the statute. Backman involves 2 brothers. One brother had worked for 27 years in the Salt Lake City School District, starting as a teacher, had risen up to become the principal of South High. And his contract, along with all of the other employees of the district, was renewed annually and was reviewed by the school board. But there was a policy that said if there weren't any complaints or any problems with your performance, then the contract was automatically renewed. As I said, he worked for 27 years. During that time, he also contributed to the teacher's retirement fund. And in order to become fully vested in the fund, you had to work for the district for 30 years. And if you left the district before then not only didn't you get the pension, but you lost everything that you had contributed into the fund. So after 27 years, I know that sounds a little weird, but it was the 50s, it was a different time. It was before me. After 27 years, his brother was elected to the school board. And the school district went to the superintendent of the schools, the state superintendent, and said, can we renew Mr. Bateman's contract? And the superintendent didn't know, so the superintendent's office went to the state attorney general's office and asked for a legal opinion. And the attorney general's office said, well, based on the way the statute is worded, and it had just been amended, no, we can't renew his contract. And so 3 years from retirement, imagine all of your retirement being taken away at that time. So needless to say, he brought suit to challenge that. And the Utah Supreme Court looked at this and said, well, now wait a minute, that's not fair. It is it's kind of an illegal taking. He's contributed to this for 27 years. No other school district in the state can afford to pay him at that level. Salt Lake School District paid its principals more than other school districts. And there has been absolutely no indication that either he or his brother have done anything wrong or illegal or corrupt or anything. This is just a circumstance of fate. So the Supreme Court said that if the appointee was already in place when the relatives are elected as a public official, that's not nepotism. That doesn't count for the purposes of the statute, especially when you contributed all this money into the retirement fund and you can't get it. So there is this exception written into the statute today that basically says that nepotism is sort of forward-thinking. The public official is elected and then appoints a relative. If the relative is already in a position first and is qualified and there's no signs of corruption or malfeasance or anything, then the statute does not apply. So this is the most important case dealing directly with the nepotism statute. Second, Baumgartner versus Salt Lake County, 1977. This dealt with the employment of the wives and daughters of some justices of the peace that had been hired by the courts. All of these women had prior courtroom employment experience. So it's not quite the same. It's not hiring someone who doesn't do anything. But they were hired to work in the same courts, same court systems where the justices of the peace were employed. And county residents in Salt Lake County brought suit saying that seems to be in violation of the nepotism statute, as well as the Utah state constitution. And again, the Utah Supreme Court said, in this case, yes, that is a violation of the nepotism statute because of, as Susan was talking about, that issue of direct supervision. These court clerks would be directly supervised by their spouses or fathers. And that's a different situation. And this is significant because this still falls under the nepotism statute, even though the judges themselves, the justices of the peace themselves, were not the ones making the hiring decision. It was the county commissioners that were doing this. But because of that supervisory relationship, that's what brought it afoul of the nepotism statute. And last but not least, there we go. Bringing us into the 21st century, Urine versus Timchick School District. This decision, if you read the decision, and we provided it with you, there's not a lot of background to this. And this case is cited quite extensively for other parts of the decision. One of the plaintiff's claims was that the school district was in violation of the anti-nepotism statute, and that gave her a private right of action to sue the school district. And the Court of Appeals came down and said, no, not quite. Unless the statute, and this is one of the things that this case is cited for, unless the statute specifically says that the individual has a private right of action for violating the statute, you don't. So the Court of Appeals dismissed the anti-nepotism claim because she was making a private right of action, a private cause of action based on violation of the statute, and the Court of Appeals said that that wasn't appropriate. It did.
So my question is, the 1977 case, the taxpayers brought suit. That's a third-party tax payment, or was he doing a taxpayer duty standing?
Well, the difference is, as I understand it, after reading the cases, is that in the Baumgartner case, I'm going to say that umlaut A is my German language there. What they were seeking was to have these clerks dismissed from office for violating the statute. They weren't, the taxpayers weren't trying to get any kind of monetary recovery as a result of that, whereas she was. That's part of it.
And one other point with that particular case, and it was not really a taxpayer, is that it was based on a constitutional provision in the Utah State Constitution that says that you cannot have relatives working for the judges and the judiciary. So there was a specific constitutional provision that prohibited it. So that would allow them to bring that claim as taxpayers. Maybe they wouldn't be allowed to do it in connection with one of these other situations that didn't have a specific constitutional prohibition.
I should say this is back before I went to law school. I taught for many, many years. I do encourage people, if you do have questions, please feel free to ask. My experience from my classroom experience is that if you have a question, probably 3 or 4 other people in here have the exact same question. They're just afraid to ask. So you're doing them a favor by taking the pressure off. All right, we have looked at county policies from a number of counties, not every county, but we found a number of them, and we just want to highlight some of these policies. We're not going to mention which counties these policies are from, so we won't put anybody on the spot. And as we looked at the policies, we found basically 2 broad categories. There are some county policies that have very simple statements, and I'll show you those in a second. And then there are other county policies that go into much more detail about their anti-nepotism policies. In general, one of our best practices that we'll get to later, we prefer it if your policy is more detailed, so that everybody, all of your public county officials, all of your employees are all on the same page. They all understand the nuances of policy. So first off, we've got some simple statements. Just walk over here, and I'll talk a little louder. Thank you. All county employees shall comply with applicable state laws as per Utah Code annotated. 52-1-3. Now I want to point out something here. That's the wrong statute. So in your policies, please make sure you reference the correct statute. Otherwise, it's no good. So, it shall be the policy of the county to comply fully with the provisions of sections 52-3-1, got that right, 52-3-2, Utah Code annotated, prohibiting employment of relatives. Any public officer who violates the provisions of section 52-3-1 or 52-3-2, Utah Code annotated, is guilty of a misdemeanor. No public officer may directly supervise an appointee who is a relative when the salary, wages, pay, or compensation of the relative will be paid from public funds except as allowed by state law. And
finally, it is the policy of the county to comply fully with the anti-nepotism clause as stated in the Utah Code. All of these are from different counties, so these are 4 different policy statements. Do you see any problems with these? Other than the typo in the first one.
Which is probably our fault.
No, that's in the statute. That's in the statute. That's from the website. So, I mean, yes, they all say.
I don't know, if I was starting out, the third one seems to be the best. It at least gives a little context, but like the fourth one, I'm like, gosh, I don't even know where to look on that one. And I don't even know what the rule is.
Right, you don't know where to reference it. You don't know what the anti-nepotism clause is. And so how do you, as county HR people, the county officials, enforce this? If you don't know, if you can't see what it is, if you don't know what the terms are, how do you enforce these policies?
It'd be nice now not just quote the statute, but then to also list it so that they've got a paragraph saying, here's what that says.
Here's what that means. And here's, the second one is pretty close. I mean, these two are better. They give you more context, as you were saying. They give you more of an understanding of what it is.
So it needs to give us a little bit of what we're going to do about it if we're find that it's an issue, because it says it's guilty of a misdemeanor. Well, so what?
Yeah, exactly.
Are we going to file it with the court and get that person a misdemeanor?
And it doesn't give you any policies or procedures as to how the county.
Or are we going to rectify it somehow by moving them into a different department?
Exactly.
And it doesn't really define what you mean by these different terms, so you don't know if you're complying or not. It's just kind of a very vague statement. So
Yeah.
that's why Lewis and I both, as we were looking at these, thought you need to have more substance there, more procedure there, more next steps there, what you do in a situation. For example, I'm jumping in here, but for example, we all know that sometimes, and this probably has happened in your situation, where you have a man and a woman that are working for the county, they date, they end up getting married. What do you do in that situation? And of course, this dovetails into, again, what we talk about in our EEO training, is that if, romance happens, and we all know that there are people, I'm sure that in every county that's represented in this room, there are examples of individuals that are married to one another that work for the county. But what do you do in that situation? And one of the things that we always emphasize, and that you'll see as we go through this, is certainly the first and foremost thing to do is to be honest and upfront. Talk to your supervisor, talk to HR. HR will be charged with the responsibility of making some reasonable changes so that they are not in a direct reporting relationship. And maybe it will necessitate putting somebody in a different department or what have you. But the first and foremost thing we want to tell our employees, as well as our supervisors, don't just sit on these issues. If this issue develops and you see that it's happening, take some proactive steps yourself to try to address those issues. So it doesn't become a problem for anti-nepotism, it doesn't become a problem for conflict of interest, or it doesn't become a problem for conflicts of interest within the workplace or EEO or any of those kinds of things, because that's where these problems come from typically when we see them by the time they get to us as lawsuits.
Okay, so these are the simple statements. Now, I'm going to move on. The next few slides are one county's policy. So compare this with, okay, so here's, all of this is part of their anti-nepotism policy. So it's a policy of the county to comply with section 52-3-1 as amended, prohibiting the employment of relatives. So it defines what an appointee is, what a public officer is, what a relative is. All of that's taken straight from the statute, the statutory language. No public officer may employ, appoint, or vote, or recommend the appointment of a relative, blah, 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 blah. And here are the exceptions. They should sound very familiar if you're paying attention to what Susan was saying earlier. There's page 1. Here's page 2. It gets really small. This violates all good PowerPoint presentation etiquette, but I like doing this to show you how detailed this is, and this is in the materials that you have before you, so I won't go through it all. And it talks about the supervising, talks about the exceptions, talks about all of the things that we've been talking about so far. Okay, so let me go back before we go into that. Much better? Gives you a sense of what makes Joe happy there. Makes him what?
Can you just tell us which county that's from? I mean, it's positive, right?
Yeah, this one,
Is this one, is either Uinta? Is this one?
it might be Weber.
Is
This one might be
Is
Weber
this
County.
one?
I'll have to go back and look at my stuff. So.
Yeah. Well, this is.
Are you guys
I'll go back and
voted
look.
over there?
I'll go back and look. That's a good.
Yeah.
All right, so here's example number 2. This.
Now, I think this one is yours, isn't it, Joe? Example 2. I know that we had Uinta.
I know we had Uinta.
See, they never have any
Yes.
problems
Yeah.
out in Uinta County with nepotism,
But-
so
but-
this is forgotten all about.
You'll see, there are some differences between that first example and Uinta's blazing its own trail.
We don't quote this.
They don't quote the statute. That is one thing that we notice. So, again, in order to avoid favoritism, the appearance of impropriety, county shall restrict the hiring of relatives of current county employees. Policy applies to all county employees and elected officials. Employees of elected officials shall not hire or possess direct supervisory authority over relatives. And we're going to hit that every single chance we get.
Well, and when we talk about public officials, I think this, and Louis doesn't mind if I interrupt him, I do it all day long, every day, so that's the way it goes. But one of the things that I think is important to talk about too with that Backman case, and it does come up in other situations, if you have, for example, a county commission, so you have the 3 members of the county commission, and then there's, a relative of theirs that applies for a specific position. And this should apply to other county officials as well. What the statutes require and what is good policy and makes sense is that there be written full disclosure of the relationship, just as you would do with a conflict of interest and so on. But then, of course, that public official has to recuse him or herself from making any decisions relative to that particular appointee or prospective employee. So that county commissioner, that, whatever the position is, has to steer clear of voting on whether or not, or ruling on whether or not that individual should be hired, whether or not that individual should be fired, whether or not that individual gets a pay raise. They should not involve themselves in the annual performance evaluations or raises. They have to separate themselves from that individual. Yes, sir.
So, just to piggyback on that last statement. So, there is the exception. The person that's a relative can supervise that person directly because of the exception. But they can't do the performance review of that person. How does that work? Because they're doing the day-to-day supervision. They know what that person is doing. And then I am supposed to do the salary recommendations and the performance review for that person. But yet, I don't designate what that person's going to do every day. And
I think that's an excellent question. The statute does not specifically address that, but having been in an HR department as legal counsel for the big company I was telling you about, as well as doing this outside work, I don't know how you can manage that. If this person, because of an exception, reports directly to you, yet you're not the person that's supposed to do the annual performance evaluation, I think we have to get HR involved. I think we may have to get legal department involved in those circumstances. So you may have to defer to somebody else, even though that person may not have that hands-on, day in, day out relationship with that individual. But that's the best way to steer clear of any kind of legal problems, even though from a practical standpoint it doesn't make a lot of sense.
the way we've done it and I just wanted to tell me if I'm wrong, but the way we've done it is basically we both set in on that job performance and did it together, and then I signed off on it.
And are you the relative or the
No,
non-relative?
I'm the non-relative.
Okay, and I think that's the appropriate way to do it. You know, I think the concern is we don't want to show any kind of favoritism. We don't want to show any kind of special treatment for this individual. And if this individual is performing up to standard and is entitled to the raise or entitled to the promotion or what have you, then you should be able to justify it objectively. And if you do it objectively as opposed to based on, you know, whatever, using the performance evaluation, having the HR person sit in, I think that's a good way to do that. That makes sense.
Typically what I find is there's less favoritism and they're harder on that person.
Yes, sir, I agree with you. Having worked for my father, let me tell you, he was the toughest boss I ever had, but the kindest and nicest boss, but I didn't want to disappoint him, so I'm sure that comes up as well.
And I think that also feeding into that and building on that is this idea of transparency. As long as everyone understands that that's what you're doing, and then so they understand what your signature on that review means and how that came out, I think that certainly complies with at least the spirit of the statute and the idea that, again, you're not playing favorites.
That's a great point. Yes, sir, in the way back.
On the notion of recusal for a commissioner, we have left it at recusal, and you mentioned like a written disclosure as well. How would that work, I guess? I'm just thinking of the mechanics for how we would make that happen. Do they just need to write a disclosure, or is recusal not sufficient?
I would recommend you do the written disclosure as well. There is, I think it does address the issue. That way you've got a documented record of it, that it was transparent, as Louis just mentioned, that this is the relationship, this is the situation, you know, and I'm recusing myself from making this decision. It protects you if there is an issue later on down the road, that you've done your due diligence, that you've done what you need to do to protect.
So in the most recent case, in my mind, he mentioned in the meeting that his uncle, I recused myself, and not that it is the meeting, but it wasn't formally disclosed.
And I think mentioning it in the meeting is good, because you do create that record, that audit trail. But I'm sort of a belt and suspenders kind of person. I would suggest that you do the written disclosure as well, just so it's on the record. Everybody knows that nobody can say, hey, you snuck this one through without anybody knowing that this was Aunt Sally's son.
The longer and wider that paper trail is, the more you are protecting yourself and the organization. All right. Another thing I wanted to point out here is Winter's exception policy. An exception of this policy requires the prior written approval of the HR director and the county commission. All-powerful HR director. An exception may be granted if one of the following criteria is met. The relative will be employed for 4 weeks or less, not 3 months, 1 month. They're tough out there. Or the relative is the only applicant qualified or eligible for the position. So how are you going to make sure they're the only applicant qualified and eligible for the position? Post the job opening.
Post the job opening to make sure you have objective criteria.
All right.
And good.
No, leave it in.
And good job descriptions, that helps as well. The objective job descriptions.
All right, and this is the second page of their policy as well.
And I'm interrupting one other time, and I'll keep doing this.
She'll keep doing it.
The thing of it is here that I think is good as well is that right from the get-go, you get the HR director involved. And that way you have that objective person who was there making sure that all the I's are dotted and all the T's are crossed. And then it doesn't put such a big burden on the individual hiring manager or supervisor. They get the support from HR as well.
All right, so in this first part, Uinta County tells you what options are available or what they will examine if there is one of these issues arises. Could involve one of the parties' relatives resigning or being moved to another position that's not directly supervised. And then we have a list of relatives and policy, which is very similar to the statute, except for they've added grandparents-in-law. I'm not even, I don't know why, but it's worth, I thought it was worth mentioning, so I did. All right, so again, more detail is better than less detail, more discussion of what the policy entails and what options are available and what the policies and procedures are if one of these conflicts arises. So now, you stay up there, I'll move over here. We have our best, we like to leave you with best practices and recommendations for what to do. We've covered a lot of these already, but first off, have a consistent county-wide policy. So the policy has to be the same, not just for the Parks Department, not separate for the Parks Department, and the Roads Department, and the Sheriff's Department, whatever. Consistency will help protect your county and all of the entities in the county.
Well, that goes back to what we were just saying, having human resources involved in those kinds of hiring decisions and making sure that individual departments aren't going, this is a bad word, I don't know what I thought it was, but going rogue and hiring their own. That never happens, I know.
All right. Involve the HR department and the county attorney's office at the earliest stage, whether you're revising the policy, whether you're enforcing the policy. Get the people that know involved.
And not every decision will necessarily involve the county attorney, but certainly as you get higher up in the organization, and if it involves elected officials, I would think that that would be a good idea to get them involved, just so that we protect our elected officials as much as we can, as well as the hiring managers.
All right. And train the elected officials, the public officers, managers, and the supervisors about the policy, so they know what they're supposed to do.
And they understand the exceptions and things like that as well.
Yeah, it's easy to say no nepotism, but as we've seen, there's a lot of nuance. Educate the employees about the policy. Remember, the statute says not only the public officers are liable under the statute, but also the appointee is guilty of a misdemeanor for violation of the policy as well. So make sure that they know about the policy and have frequent refresher courses. Don't just put it in the orientation packet and never talk about it again, ever, ever, ever. You've got to remind everybody in your organization about what the policy is and why it's there. And finally, we put this at the end of all of our presentations, don't be afraid to ask for help. Ask the HR department if you have questions. Ask the county attorney's office if you have questions. If they can't give you the answers, seek outside counsel. I know of 2 attorneys that I can think of off the top of my head who are more than willing to help you find answers to your questions. And you'll probably need the help sooner than you think, and there's nothing wrong with asking for the help if you need it. You don't have to go this alone, recreate the wheel or anything like that. There are resources out there to help you. And I think I've got one last cartoon for you. Do you have any?
Just any additional questions or comments? We'd love to hear from you as well as to what's working in your county and whether or not there are certain things that you're facing in this area. Any thoughts?
Isn't the state auditor trying to say that anywhere in the command chain we can't have a relative? Is that what he's trying to push?
I think yes, I think that's part of the push. But, it's not this is the thing, especially in certain counties where you don't have, I mean, where it's sparsely populated, or you don't have a lot of people, or, you know, there's not a ton of candidates, that's not always reasonable. And so I think our legislature, with an anti-nepotism policy, really tried to strike the balance of this. And I think I can end, I'll say this right, with one of the quotes. This was really quite a funny little quote that came from the Bachman versus Bateman decision. What the court there said about the very strict anti-nepotism policy that we originally had back in this time frame in the 1950s. The court said, it is unwise to burn a barn to get rid of a mouse. And so I think what our legislature has tried to do since then is to strike a reasonable balance, keeping in mind the practical considerations of doing what you all need to do every day to make sure that you properly serve the people of your counties. So, any other thoughts? Yes, sir.
Just the only comment I'll make is maybe you got some comment you make back, but it seems like just as I look at your family and how you're all involved in the law, in law enforcement, a lot of times we run into difficulty with nepotism because that same type of this is what our family does seems to run through it. It makes it very difficult to sometimes avoid nepotism.
And I think you're absolutely right about law enforcement, because it does become sort of a vocation for the family, you know, and I think that's really true. You see it all over the place. And so I think that there are some really good things about that as well. I mean, maybe that's a real inspiration to the family to do this job, and, you know, this is what we're born to do kind of thing. But on the other hand, I think if there's a way to avoid that direct supervisory relationship, then you can make it work. I mean, you know, if you've got a situation where, well, and when we talk about direct, say you have an elected sheriff, and the elected sheriff has a brother that is in law enforcement as well, as long as that brother is not reporting directly to the sheriff, so maybe they're over in another division and they report up to the jail commander or something like that, that will probably give us enough space. And as long as we document it, as long as we get, you know, buy-in by the HR director and by the county sheriff, then I think we've covered our bases. As long as these two individuals understand that they don't get special favors as a result of this, that they don't get to say they're the ones that get to take off every Christmas season together, you know. I mean, these are some of the issues, the real practical issues that we find if there's relatives and there's nepotism, is that, you know, they get the same vacation days, they get the best job assignments and things like that. That's where we run into the real issues. As long as these individuals understand the policy, procedures, and they take the proper steps to be transparent, then I think we can work around these issues for sure.
Transparency, being open and getting the buy-in from HR and the county attorney and the county commissioners, I think helps resolve some of those issues.
Okay.
I said, I think I've got one last cartoon.
Oh, there's...
This is highly motivated, outgoing, and independently minded. Isn't that right, Dad?
I tried that line myself. Well, thank you very much.
So thank you all very much.
So just a couple comments. With the direct supervision, that's definitely a big issue right now with the state auditor's office. You know, sent out his auditor notice that he does intend to say it's anywhere within the chain of command. That came directly out of his review of fire districts in particular, and special districts is really his big problem right now. So those of you who are part of or oversee special service districts, watch out, he's on his way to your door to do his audit. And again, he's backed off on that somewhat. I talked to an individual high up in the AG's office that was part of a team that rendered him an opinion when he asked for it on that very issue, and they said no, direct supervision means direct supervision, and he chose to ignore that recommendation from the AG's office and go his own way. So you'll probably still have that fight. So at least know where your nepotism issues are, and the things that clearly are violations of statute get cleaned up. You might not be able to take care of the direct supervision issue. If that's going to mean 3 levels down, it's still considered direct supervision, but at least take care of they're not recommending merit increases and they're not doing performance appraisals so that you're in good shape in the course. The other issue when it comes to being in good shape in the course is, as I looked at those policies, even the more detailed ones, what I missed was, some of them referred to, we're going to be in compliance with the statute, and then they regurgitate the statute. Yeah. So how many of you have a full-time policy analyst, policy review person, who every time the law changes, every March, when the new statutes go into place, when a court case is decided, that person goes through every single policy of the county and makes sure that they're all up to date based on that new court case or new statute, right? We've all got those people, right? No. So, number one, when you write those policies, because again, our position on it, the guys that have to defend you, and Susan that has to defend you, better to have a more minimalistic policy that you can follow than copy Utah County's fantastic policy, which there's no way you can follow because you don't have the staff, you don't have the resources. You will kill yourself because you've now set that bar that you will follow that policy when you know you can't. So develop a policy that you can follow. It should be the minimum of the statute, but I would recommend, one of the things that was missing in all of those was to clarify, and this is again a policy decision for your governing body, is the policy of the county that we will just meet the statutory requirements and no further than that? Or is the county going to have a policy where they're going to put additional restrictions on employees when it comes to nepotism beyond what the statute requires? Like disclosure, notice provisions, and things of that sort that aren't necessarily required in the statute, but you as an organization want to require that of your employees, and make that clear in the policy. Because if all you want to do is meet the requirements of the statute, then say that, and that if the statute changes, any portion of these policies that are no longer valid because of changes to the policy or case law, it validates that portion to the extent that we come back into compliance with the new law. Something along those lines. Speak to your expert attorneys who will help you draft that language. But I think that's really important, that you don't go out, find a really good-looking policy, put it in place, get it approved, and then let it sit on the shelf for the next 10 years because you'll be in trouble. Okay. All right. So, before the daylight's gone, thank you all for your attention today. We'll get started again 8 o'clock with breakfast. 8:30 we'll get underway with the presenters.